Good morning. It's a pleasure to be here. This is my second state. My wife is from San Antonio, so I spend quite a bit of time down here. So I happen to know quite a bit about the state of Texas in many levels. And I have a couple of things to do this morning. But I want to first ask Jim Bethke a question. Why are we here? What have you done for the past 10 years?
I'm the beginning step right after the break. No, actually, there's been a lot that's been done, but Jim, what I'd like to do is then turn it over to you.
Good answer. So I'm asked this question all the time. Why are we doing this? How do you get away from the power of the anecdote? When somebody talks about indigent defense and you hear the story of the person who has the yacht, the car, the house, they're not indigent. They've got a job. Why do they get a lawyer? And you hear the power of the anecdote all the time. And I always talk about public defense, not indigency. It's the issue is, can you afford a lawyer at this time when you're charged with a crime and you need to be in court tomorrow? Can you get the money together to get a lawyer? Because the lawyers want the money up in front. We can tell the answers to that. Where I hear all the accomplishments, and I heard the speeches this morning about improving efficiency and quality. How do you tell that story? How do you measure that? And I can tell you lawyers hate the word quality, that somehow they're going to be measured as to why they did what they did, why they asked this question and not that question. And it's down to the one case and what is quality. We're here talking about mass delivery systems, and we have numbers. And we heard one this morning about the judge who wants efficiency in the court. Pro se defendants are really a drag on moving your docket, not moving your docket in the sense of an assembly line without some sensibilities of justice being done, but they want the court to move in an orderly way so that people can get at the issues, the meat of the case, very quickly. That when you get witnesses in court, the time's well spent, that people are organized and things are done. Well, how do you quantify that? When I read through some of your reports, and the issue is I see these conclusory statements. So what I'm going to talk to you today about, and I can't cover all of it, is to give you some ideas as to why this matters and what you should be thinking about. I'm going to I talked about the power of the anecdote, and I'm going to tell you some stories. Anecdotes. I once was giving a speech with John Grisham, and John Grisham is a very good public speaker. And he happens to be from the South. So I get up and I start telling all my statistics. I'm running out this issue and that issue and why this was the National Conference of Chief Justices, why they should commit to public defense reform. John Grisham was there because he writes novels about this and he happens to care about this issue. John Grisham gets up and tells the story of A Time to Kill. You all see that movie? He tells another story about sitting in the courtroom as a young lawyer in Oxford, Mississippi. And he tells another story and another story. And I still to this day remember those stories. I guarantee no one remembers what I said at that conference. Those anecdotes were powerful. Politicians, Ronald Reagan learned the power of the anecdote, both to advance his cause and destroy the cause of others. The power of the anecdote. We get up and we tell the story about the person who was destroyed their lives because they got convicted at 15 of some misdemeanor. And they couldn't get a job that they really wanted. They couldn't get in the military, whatever it might have been. The power of the anecdote. So here's one of the first anecdotes I ran into. I went out to a county commissioner in the state of Michigan telling them why they should improve their public defense system. And he sat there looking at me and he leaned over and, excuse me if I offend somebody with this, and he said, ain't a goddamn vote in it. And he said, I looked at him, he said, why should I do it? I said, I'm not a lawyer. It's not my job to do quality. My job is to get the cheapest price for the county. You lawyers come in and say any lawyer can do this work. You set standards, I'll follow them. When I build a bridge, I bid it out under BOCA standards. I know what standards are. Pass them. I'll follow them. Till you do, I'm getting the cheapest lawyer in here who says he's doing a good job. Till you just bar him, good enough for me. I had to answer that. So then my mentor, when I clerked at the Michigan Supreme Court, set up this meeting with this old lawyer, part of the auto founding family, who was a senator in Michigan forever. And I go in to talk to him, and I'm all 27 years old, and I start just thinking I was a lobbyist, and I'm in there, and I'm giving him all this information, and I'm just, he stops me. He said, who are you? And I thought he was deaf. So I raised my voice, and I started over. He said, I can hear. He said, who are you? Why, if you're so damn good, haven't I ever heard what you've done? Tell me what you've done. You got 5 minutes. And he said, look, stop sounding like a lobbyist. He said, your mother spent good money to send you to law school. Think like a lawyer. You got 5 minutes, and I'm the worst jury you ever saw. Tell me why I should do what you want me to do. What's it going to mean to my constituency? Make your point. I had no numbers. We had no statistics. We didn't do an annual report back then. And when we did do an annual report, we wrote it for my commission. We weren't thinking strategically about what we put into it, that ultimately this is a document that has gold that I can take and tell people why they're spending money on my office, what difference we make. So that became sort of, those two stories became driving me as a lawyer who was very good. I won 70% of my appeals, and anybody who knows law, that's damn difficult to do. I was a lawyer, and now I'm a manager, and I began to think like a lawyer, thinking this is my case, my chance to make my case to this jury of non-lawyer legislators who are going to have the power to either create or not create me, to fund or not fund, to expand or not expand my office. So that became why I began to commit to lawyering. And I knew that lawyers hate to be compared to whether they are Clarence Darrow or not Clarence Darrow. Lawyers pathologically can't stand this idea that someone's going to evaluate whether they're a good lawyer or not. And I've heard judges say that when I ask them, how good is your public defense system? Well, I keep my eye on it, and I tell you, I know my lawyers are good. I said, well, what's that mean? What do you mean good? And I went back to this idea of literally taking these generic words that are used, that people use sometimes passionately to describe efficiency, et cetera, and say, how do you quantify that? How do you begin to measure? How do you break down the pieces of it and begin to tell your story? And I'm going to get into that hopefully today. So there's another reason why we're doing what we're doing today, other than the title of the conference, which is improving quality, measuring performance, and systemic standards. By the way, I should tell you about systemic standards, a little bit of my background in that, and how this led to it. The ABA's 10 Principles on a Public Defense System, I'm the principal author of that, and I spent 5 years sort of distilling it and writing it and testing it in the field before it became what went through NOADA and became the National Legal Defender Association and became the model for how you go out and look at a public defense system and look at it from the standpoint with one ear, that is, what is the duty of those creating a system? What ought the system to look like? If you measure it and ask the simple question, what's broke and how do I fix it? What am I not doing and how do I do it? Those are the 10 principles, and they're in the materials you got today. So that's literally looking at the creator, the public policy director. How do you measure a system? What do you look at to see if it's performing in an efficient manner and an effective manner? In the Fair Defense Act, we're going to go back to it and talk about beginning to organize and beginning to think about what it is that you begin to measure, you begin to look at so you can tell your story effectively, but some of the inherent problems in the words they've used. So section 71.0351F, only a lawyer can love that, says a clerk's duty is to cooperate in retrieving information required to be sent to the task force under section 71.061A. And it says the task force shall use the information reported to monitor the effectiveness of the county's indigent defense plan or policies, standards, and procedures. And section B says the task force shall annually submit to the governor, the legislature, a report containing the information provided under section 71. The information regarding, and this is the important part, the quality of legal representation provided by counsel appointed to prepare to represent indigent defendants, and the current indigent defense practices in the state as compared to state and national standards. So they do a report measuring quality. And the question is, what's quality? And it's not simply, do you have a Clarence Darrow in the courtroom? And to better understand what I'm getting at, and I think I've already hinted at it, when you tell someone you put a public defense system in your particular community, and you tell them, what was it like then, and what's it like now? Judges, the attorneys appear on time. And you'll see in some of the reports, and I'll get into it a little bit later, people are arraigned faster, people make bond faster, there are fewer days spent in jail. And then you ask, those are the standards people are looking at, well, what's the magnitude of that? What's the average, the mean of that? How many people does it affect? You begin to tell the story, and that's quality. That's a better quality. Another way of thinking about it is, and I always go back to this, if you hired a lawyer to represent someone in your family for a drunk driving offense or for an alcohol offense when they were in college, whatever it might have been, and you paid money to that lawyer, what would you expect that lawyer to be doing? How soon would you expect to talk to them? How soon would you expect them to see your client or your son, your daughter, your relative in jail? How soon would you expect them to get out? What would you tell them to do to get ready for trial? How fast would they move would they get an investigator? Would they get expert witnesses? How would they organize themselves to go forward? Well, those things, oddly enough, many portions of that are quantifiable. They begin to tell the story of what an effective lawyer does when they enter into a case, how quickly they get into the case, how quickly they begin to take control of it, how quickly they begin to present a face of their case to the prosecutor, to the judge, to the pretrial services, whoever it might be. Those kind of steps that are being taken, you can begin to quantify it. So if you look at the Act and you look at the key words that are in there, it's to report information, to monitor effectiveness, to determine quality and standards. Those are the things that are the core parts of it, but none of them tell you what any of those are as we go through it. So if you think of it another way, it's when you report to the governor, why should the governor continue to support this effort? Why should it move forward? What's happened in the counties or the jurisdictions where a new public defender system went in? How do you quantify that story as a part of what you're telling? Certainly, the power of the anecdote will be there. Certainly, you want to tell about an actually innocent person who got out. You want to tell what the consequences were on bed space and the need for more jails, or as the story goes. You certainly want to talk about, and this is something we're talking about in Michigan, when you have 90% indigency rates as an average in many metropolitan areas across America, what's the consequence of the last economic catastrophe? What's going on with the workload? What percentage of the people coming in now can no longer afford counsel? Do we really have a private delivery system? Even though when you see TV, that's virtually all you see is a private delivery system. When we look at the vast array of cases coming in, what number of those are now indigent? Or said differently, which is a new phenomenon we're seeing, what's the percentage of people now going pro se? You heard what the consequences are of people going without lawyers in court. Well, what's happening there? Well, it turns out that number's increasing faster than anything, because the fines, costs, fees, and penalties that people are getting, they can't afford, and they turn down a lawyer because they told, if you get a lawyer in some communities now, you pay $2,000 or $3,000 for this free lawyer in fees. Well, to poor people or people who don't have a job, that's a very daunting amount of money. So now you have more and more people, because of the downturn and because of the need, the counties and the cities don't have money, they're imposing these fees, more people are waiving counsel. And more judges, because the fees are, their funds are limited, are beginning to literally tell the right to counsel in a way that almost precipitates a waiver of counsel. Not correct, but that's going on. So you want these numbers to begin to tell a story about the pressures that are even happening in the last several years. And I'm here to tell you that the impact of the downturn on the county budgets, those relying on property taxes, is yet to occur. Because as property values are falling and assessments begin to go down, we're now seeing, years after the collapse, those impacts now starting to hit local government all across my state, and I'm hazard it's true all across the country. So you want to tell that story in a quantifiable way when it comes to public defense. Now there's another question you come up with in the issue of quality, and it's something that I learned very early on. I used to get calls from people, and they'd ask questions about what we're doing, and they'd say, we'd come from a judge, and they'd ask for data from the judge's perspective. Then they get a call from the media, and they wanted to know what our win rate was, our reversal rate compared to the private lawyers. And then I get a call from the legislature, and they wanted to know what our cost per case was. And they get a call from county supervisors or my bosses, and they'd say, how much work are you doing? What's the workload of your lawyers? What's it compare lawyer A to lawyer B? So everybody had their own perspectives about what they meant by an effective quality program. And I could literally say there were 4 or 5 of them, and our database literally was set up for me to count cases, what my lawyers were doing. At the end of the year, I did a report. We got so many of this case, so many of that case. That's the way I set the database up. And I couldn't literally go into the database back then and ask the question the way the person who's sitting there wanted to know it. So I had to think strategically in advance when we set our databases up, the kind of data we collect, to literally anticipate what kind of data I wanted to keep for these different constituencies that ultimately I had to go out and talk to. And that was a really key change, that I began to think strategically about the data I kept. Conversely, I kept data that no one ever asked for. And it's very costly to keep data. It costs, somebody has to put it in, somebody has to count it, you got to put it in the report. And so we went back through and thought strategically about not keeping data. So we began to keep data in a way that literally provided essential information. We found efficient ways to collect it, and then we made sure that our reports reflected and used it in a strategic way. again, against the touchstones that we began to think about were important. The second thing that we began to look at were these generic statements, and I'm going to read off a few of them. I was actually going to begin with this, but I'm getting to it now. It says, he's good. I'm better. She knows what she's doing. This is what judges often say. The clients like him. He does a great job for the money. He does good work. I do more than just work on cases from my staff. He cuts corners, if you're saying it negatively. These are phrases that we hear every day about what's going on within a particular system when it's not quantifiable, when people are literally talking passionately about the fact that their system is working or is not working. And I can tell you, you'll hear it all the time. And the issue is to think like a lawyer when you hear these words and you begin to say, can I quantify that? Can I begin to count that? Is there a way that is a measurable? And the answer is almost invariably, at least some part of it is. Like, do they show up on time, et cetera? Do they get their bond motions for bond reductions filed timely? Do they file motions? So you get that perspective. The second perspective is, what are you looking at? Are you looking at one case on this day, a snapshot, what the lawyer was doing? Are you looking at 1 year's worth of work of one lawyer, or in a mass delivery system, many lawyers? Are you looking at the evolution over time of these standards? How long did it take the lawyer to resolve a case from assignment to disposition, be it diversion, dismissal, a conviction, whatever it might have been? What's that time of disposition? How long did it stay on a pending court calendar? And has that system or that lawyer diminished or expanded that over time? So you can measure things over time. What was it like before we had the system, and what was it like after the system? And I asked Jim, did you go in before you put a system in and do any baseline data to see what was the impact? What did the people get for the money they spent? And did you look at the right things before you began and after you began so you can measure? If you haven't done that, are you looking at the evolution of it as part of the system comes online and others come online? Some come online, some don't come online. One county has it, one county don't, and they're comparable. So you can begin to talk about why should the next county or the next jurisdiction improve their system? What's the advantage to them, and how do you quantify it? We'll get to that a little bit later. Some more in that area. Then there's the second issue of monitoring. We talked about monitoring. And the issue is, are you doing active review? That is, somebody goes in and sits in a courtroom and watches what someone's doing, or someone comes down and literally spends a week or a day or does an evaluation where they're literally watching what's going on at this moment in time, which we use in my jurisdiction as more passive review, where you have these timelines and standards and you keep the data over time, and if an alarm bell goes off, you begin to go look. And I'll give you the classic one that you as managers might use. You have an employee, and the employee is performing in her annual reviews, or anecdotally, however you look at it, at a level of, say, B. And all of a sudden, you go in and there's a D level of performance. Over a period of time, they're not performing. So you measure, not against any external performance, this employee is now doing worse than he did before. And I've had that happen to me twice, and it turned out there was a substance abuse problem going on. Because we did do this monitoring, we looked at it, and it's passive review. Alarms go off, you go in and look. The same with lawyers and my staff in appeals. When they were performing at a certain level, and all of a sudden that level of production and output began to decrease, we went in and looked, and we found out what was going on, and we began to fix it. That's passive review. You wait for a standard to be set, and then it's not met, and then you go in and look. Active review is a much different approach and much more intense and much more costly to run, but there are two different ways in which you can begin to look at what people are doing. But you're looking for changes. You're looking for a level of performance measured against an external model, an average model, or against their own performance. Now, what I'm going to talk about and take you through some of these materials that we've put out and give you some examples of how we can work with this in the materials you've got before you. Let's talk about case counting. I'm an appellate office, and so we used to get into the issue of how much work do you do? And the Court of Appeals would come in and say to me, well, we only have 492 of your cases, but you're saying you've got 980 cases. What's that mean? The Supreme Court would come in and say, we've got 320 of your cases. The trial courts would say, on remand, we have 410 of your cases. And I only had one client. I got to talk about one client. But every time I went to a court, that court counted it as a new case. And our cases would go into the trial courts, they'd go in post-conviction, they'd go into the Court of Appeals, they'd go into the Supreme Court, they'd go to federal court, district court, circuit court, the U.S. Supreme Court. That's one client. 6, 7 different courts it would go through, but each court got to count it once, but I only got to count it once total. So I began to break down the work that occurred in the case in ways that would reflect what lawyers do on the work, not counting the client, but counting opening pleadings, counting briefs, counting the structure of what we were doing to point out the work we were doing that wasn't necessarily being done by the private bar, and indeed it was not being done. So we began to change from caseload to workload, the concept. And we began to do it in a principled way. We didn't go in and do it indiscriminately. We literally did time studies, we broke it down. And we began just to tell the story of how much work we were doing. An outgrowth of that became the ability to literally over time begin to look at what an average workload was for a lawyer in my office doing different types of weighted cases. We also had 10 years of work data, how much work the lawyers actually did. What this led to was one of the first case-controlled intake for defender offices in America. We began to control our workload. And literally, we stopped our intake based on how many lawyers I had in service at that time to do the work. And literally, these standards have been working over 25 years now. It's now automated. A computer does it automatically. We declare what our capacity is, and the computer regulates how much work we get. But it came out of keeping this data just to tell the story in a meaningful way of how much work my office was doing compared to them counting only how many named clients I had. And there was a radical difference between the two in terms of total workload. And if you look in the materials, you'll see some of these reports, and they begin to appear roughly around page 11 in the report. And these are reports we generate regularly to manage the workload in our office. Now, this is called a management-only report. You'll see it. Only managers can see this report, and I took off the names of the attorneys, but it literally tells you exactly how much assignments came in, what the consequences of that were, how many pleadings were filed, and what kind of results they had. But at the end of it, you'll see there are averages. We give the average to all the attorneys. They can see the office averages, and then they can compare their reports, which they have access to automatically on our system. They can see any report we generate about them. They can see and compare to what the averages are. So we literally let the attorneys see just the data. We don't manipulate it. We don't control it. We just put it in, and they can see it. Now, this has to have a story told behind it in terms of, was an attorney on a pregnancy leave? Did they have a U.S. Supreme Court case where their caseload shut down? There's more information that comes that makes it human, and that's put in to the report about each attorney. We've had 3 or 4 cases in the U.S. Supreme Court in the last couple of years, and so that literally shuts down a workload for someone, and that work flows out to other attorneys in the office, and they can see the work flow out. They can see the consequences of it. We don't keep it from anybody. We also, if you look at the first part of the report, you'll see if you went to our website, you'd begin to see these pages on our website. We make all this information generically available in our annual reports, and we have every report we've ever done since 1971 online available. So when the legislature thinks we're keeping some information from them, we refer them to the website. Everything's there. They can go back and do the same linear studies that we're doing about, for example, productivity per employee. We put that information out. With automation, our productivity has gone almost tripled in the last 20 years, how much products put out per employee. This is information that we want to show when we start talking about efficiency. So we literally make it transparent, we make it available, we let people see information that compares them to the averages. We do the same thing for my sister agency for the private bar, who are doing appointments. We literally put the same kind of, similar, not as detailed, but similar types of information out so people can see what they look like compared to the average. Now, that transparency and that level of information, that granular level of information, allows you to go back to the funders and go back to the policymakers and talk about what we're doing, why we're doing it, why it matters, and what the benefits are of what they're doing. Because we can show the impact on the Court of Appeals docket, on efficiency on their dockets. We can literally give that kind of information out to them. Now, the second thing that comes from this, and you can go through these reports and you'll see the issue of major pleadings and weighted caseloads, and I won't bore you with all that. And I'm not making a case, by the way, that you should keep this information. We're not at all. I'm not going to tell you what information to keep. I'm going to show you the value of keeping it and what you can do with it. And on page 20 in the report is the next level of information, which I call, the first information is mechanical, it's protective, it's defensive information. in some respects that describes what my office does to convince people we're working. On page 20 is a report we filed on the U.S. Congress about the consequences of bad defense systems. We also keep data on what our lawyers accomplished, that is, down to the level of days reduced from sentences. We keep months reduced, years reduced, new sentences imposed. We track all that information because if we reverse a guilty plea sentencing, we go back and do that resentencing, and we talk about the time differences we get. And I've seen that in some of the reports that are in here about the time reductions and the time people spend in jails, and you'll see it in some of your reports you submitted. But we took it to the next level. We then went out and literally put a price tag on it. We went out and got the standard figure used in a particular jurisdiction, a county or a state, as to the average cost per bed space that they use when they're talking about the need for a new jail or what it costs them to house people in the county jail or in the state prison on average. And we literally put a report together for Congress that showed in our office of the cases we take to court on sentencings, because the trial bar in Michigan is so untrained, so unknowledgeable, that we reverse almost 70% of the sentences and get time reductions that we take. Now, no client ever knew they had a bad sentence. This is simply we get in and do the guideline sentencing over again and find that there are improper prior record variables in it, improper offense variables, and we go back to the judges who impose the sentence, and they put in the correct sentence, and it literally takes 3 months off here, 2 months off there, 5 days off there. But the aggregate total, when we projected it out, was $69 million. If we projected it out to the non-appealed case, that number goes literally over $200 million, just in literally errors in the sentencing process. Now, that got the attention of the legislature about what's wrong and what's broke at the trial level when you don't have trained lawyers, because it's concrete, it's real, and it's powerful information. The second thing we did was look at exonerated people, and we began to put a price on exonerations. Now, we don't have the death penalty in Michigan, so it's not as flashy, and you don't see it on the front pages around the country when people are removed. But we took some of the cases where there was an exoneration, people who spent 18 years, 22 years, 19 years in prison, and we looked at both the years in prison cost of that. We talk obviously about the guilty person still being out there. In one case, that guilty person committed 2 other murders when they were out. And then we literally costed out just the bed space that this person wrongfully spent in prison. We talked about the appellate costs of that, and it's in this report. And we literally quantified those, and the judgments. Every one of these, the judgment was over $1 million, some of them $4 or $5 million for the wrongful conviction against the counties. But we quantified it there, and again a consequence of an inadequate trial defense system. So we've literally gone and taken our data, and now we're using it in a way proactively to demonstrate that there is a real way you can quantify the consequences of not spending attention and time on having trained lawyers represent people in these mass delivery systems. And let me just make a point about that. What we've got, in a sense, is not the concern. Whenever we hear people talk about public defense, they will talk about one case. When I'm up here talking, I'm talking about a system that might have 50,000 cases in it, or 110,000 cases, or 200,000 cases. And when you begin to see those numbers and you begin to extrapolate them out, you now can start talking about keeping data in a very important way. Not necessarily to tell a meaningful story about the one case within that bunch of 50,000 cases, but you begin to be able to tell a story of the consequences of a mass delivery system. When you have a county that's literally processing through 584 cases, and it results in, by having that, a general reduction of 13 days in jail for some significant portion of those, you can take these large numbers and begin to tell a very important story about the consequences in a way that might not appeal to Clarence Darrow in talking about a system, but does compel people who are thinking about reforming their system, maintaining their system, perhaps eliminating their system, and getting away from the power of the anecdote. And I'll show you in one of the reports that was done, and I think Jim puts this report out every year, and it's called Programs, Processes, and Technology, an Overview of Discretionary Grants Funded by the Texas Task Force on Indigent Defense. And if you go through that report, you'll see, and I'm not picking on anybody, I'm just talking about what was done and an opportunity missed. On page 8 of that report, I think it's Kaufman County, they talked about within months of the PDO's opening, the average daily jail population shrank from 430 to 225, and the sheriff now rents out roughly 70 beds a day to other counties. That's a very powerful piece of information. Well, convert it to money. What are we talking about here over the course of a year, over the course of 5 years? Those things can literally be put in there. Now you're telling that story in a much more interesting way, in a much more anecdotally powerful way. And instead of putting it down as Kaufman County, if you organized all the counties where this happened and literally told that story across a broad spectrum, if that's the way you choose to tell the story, then I think you literally lead with that and you literally talk about that measure, and it's a story to all those who have not reformed about what possibly could happen, not necessarily will, but possibly could happen in their jurisdiction. And if it resonates with them, if they say, yeah, we do have that problem, then they can look and literally see the consequences on the ground in neighboring communities to theirs. And if you go through this report, you're going to see that time and again. You'll see generic statements made about we improved the quality, we improved the efficiency, but no literally standard against which that can be measured. No Texas standard, no national standard used. If you use the 10 principles and you put them in, or standards developed by the Fair Defense Act, and put them in and see how you're doing against it, and quantify it, and literally make those very powerful statements about why you did what you did, why you want to keep doing what you did, and why you hope others will do it. And I think it can be done. The last thing that I'm going to talk about is a document that I think is raw gold, if it can be literally mined. And that is the model attorney fee voucher, which I understand when they developed this one took weeks and weeks of negotiation to get this done. But if you look at the opportunities missed throughout this of capturing information from the very lawyers providing the service, along the lines that I've been talking about, trying to quantify in a way and accumulate meaningful information across a broad spectrum of communities from the very lawyers providing the service, the things we require in my office. By the way, I will tell you that lawyers are the weakest link in any information system, by far. They literally hate doing it. But when they're getting money and you're giving them money, this is some place where they might just do a slightly better job of providing meaningful information. So here are the kind of things that I'd be interested in that you might begin to look at on it. When you talk about when they were appointed. So when they were appointed and when the case resolved, those 2 dates. That's something you want to track and see if you start seeing, which I suspect you will, you're going to start seeing that these dates start declining. So the time that a case sits in open active status begins to reduce itself. You want to literally make those dates start to pop out. You want to see if the client was in custody and the date they were released from custody. And that can happen in a variety of ways, but those are dates that you literally want to track. You want to see what the original charge was and what the closing charge was. You want to see if there were conditions of bond, what those conditions of bond might have been, when those were removed or when those were increased. You want to see what kind of motions were filed, whether an investigator was hired or requested, whether an investigator was appointed. Was it denied or granted? Was it an expert witness asked for? Was it granted or denied? You want to see these kind of things, literally begin to mine the things, because there's another story to tell about that, about other problems that might be inherent in the system. That is a continual and pattern of denial of the request for investigators or expert witnesses. And by putting it in here, ultimately lawyers begin to get the point that there is something going on here, and if you tell them why you're getting the data and how you're going to use it. By the way, I'm not making a case to do this. Trust me, I'm just talking about what you can do when you're asking lawyers for information that they know matters to quality. And you've got this document in every case, if they're getting paid through an assignment system or a defender system in terms of what they would put into their database and begin to report on. So this kind of information, and of course the issue of fees, the fees requested, the fees actually paid, those kind of things can be put in here. The actual number of hours the lawyer spent, this is a really powerful one. The actual time they spent versus what they were paid. And it doesn't take a genius to know, divide that. What's the average cost per hour? The average pay per hour. And we have lawyers in Michigan working for $7, $8 an hour. And that's paying their overhead. Well, we all know their overhead on an hourly basis is somewhere over $65 if they have an office. So you can literally say that a lawyer can't survive and will not continue to do this work, or it doesn't take a genius to say they're going to do good work for the money. What are they doing for it? So capture that data from this document in a way that would, and then finding a way to literally scan these in, to put them online, to make them available through a generic, we're doing this in Michigan, which literally now when anybody enters it, it would be sent electronically, but also come up to the Fair Defense Act, so they begin to mine that data and begin to tell a story in a much more coherent, powerful way. So this is a gold document here for gathering information. But most often, these kind of documents go into a file and nobody ever aggregates or looks at them because it's too difficult. They're done in a way that isn't meant for that. It's done in a way that gets a lawyer paid for what they're doing. And if they know the standard fee has a cap on it, or they're only going to get paid for so much, these become what I call dream documents. They put in sort of what they can think about, and they don't keep accurate records. But if this becomes a meaningful document that literally might help them get a higher fee, or ultimately change the fees, or ultimately get them more services to support them, you might find an incentive to begin to start treating them more seriously and start to aggregate more important information. So that's my story. That's my anecdote about answering those two questions at the very beginning. When there ain't a goddamn vote in it, why should I do this? What's in it for me? Or telling the story in 5 minutes to a legislator who isn't motivated, who isn't passionate about the issues, but has to choose between 10 priorities. Why are they going to do this one? How are you going to tell that story so it literally resonates with them, not only that I can sleep at night providing this representation, but why they might do it for a totally different reason and have a compelling reason for doing so. And that's why I think performance measures matter. They can be done, and they are very powerful things when you do them properly. Thank you.